Good morning, friends. Today we are going to discuss very important topic of what is a patentable invention. Okay, all these years people are interested in doing a patenting, but they are not sure whether the invention is patentable or not. So, if we bring clarity into what is patentable, so there can be many more inventions and inventors forthcoming to do register their work as a patent. So this awareness of the what is patentable is so important. So we'll try to address this question in today's lecture. This is disclaimer. The IARE is not responsible for the accuracy of the contents of this presentation, even though care is taken to present all relevant facts and to available to the author. This is my profile for information. Yeah. To first understand what is a patentable invention, first let us understand who gives the patents. Patent is given by government through a patent office of that country. In India, there is a control of patent, designs, trademarks, geographical lists. All these IPs were controlled by one office that is called Patent Office of India, IP. So they have many branches. Actually, it comes under Ministry of Policy Promotion, Commerce Ministry. These are the offices of IP in India. You have this headquarters in Calcutta, and you have some Mumbai. You have offices in Ahmedabad, and you have our nearest office is Chennai. So we have wide-ranging offices, and they have one office in Nagpur too. So to go into what is patentable, let us learn what is the framework under which these patents were granted. The Patent Office is empowered by an Act of Parliament which is passed in year 1970. The Act is called Patent Act 1970. Of course, it was amended in 2002, again in 2005, and also in 2007. The first two revisions were made to align our policy of patents in line with the international commitment called TRIPS agreement. Okay, trade-related aspects of intellectual property rights. This is a commitment by government of India along the member countries. So more than 150 countries were signatory to this. So we have to keep provisions of that TRIPS agreement in line with our law. So we have to amend our act in 2005, 2002 first and 2005 later. Now recently some more changes were done in 2007 as well. So this is the broad definition. What is patent, what is patentable was given in this act under section 2.1J. Under section 2.1J. Okay. Patent shall be available without any discrimination for any invention, whether it is a product or a process, in all fields of technology, provided, here is the hitch, they are new. They must be new, okay, and involve an inventive step and capable of industrial application. All the three requirements has to wait. They must be new, they must be involving an inventive step, and also there shall be some industrial application for it. Okay, this is the definition of what a invention can be given a patent as per section 2.1J. As explained, it can be a new product or a process. It must be either product or process. Mere theory or a abstract theory or mere idea is not patentable. You should have a process or a product. Next important step is inventive step. It must be something improvement over a existing thing. Inventive step is a must. Then third step is capable of industrial application. Means it should have some public utility. The invention shall be having a industrial application, means capable of mass producing and should be useful to society, such things. The question comes whether improvement of an existing invention, can it be patented? Yes. If that improvement is novel, new improvements which is novel can be patented. So how to determine what is the criteria? In short, we call it NUS nonce test for eligibility of patent. We have to do this test for any concept. If it comes to us, we will test whether it is a novel. Novel means nothing new. it is not already in public domain. Suppose the invention is already in use in the public or already published elsewhere or put in some kind of a book or a presentation, then it is no longer novel. It should not be already in the public domain. Then only it is novel. As I explained already, utility means it should have some industrial application. Then third, this is the most important thing, you see, inventive step. It should not be very obvious for the person who is in the trade. Suppose it is a mechanical invention, a mechanical engineer should be able to derive as the logical next step. It should not be very obvious to the person who is trained in that art. Who person trained in the art means the person belongs to that field. For him, it should not be very obvious, this improvement. Right? After fulfilling these three conditions, there is one more condition. It should not be against statutory provisions of the law. So it should not violate existing law of the land. So the law of the land, whether it is violating or is explained in detailed way in section 3 and section 4 of the Patent Act. So let us first understand novelty. Novelty is the one which is the main reason for an invention. Okay. As we explained, if it is the new thing, whatever the novel features were already published, let's say in a journal, then novelty is lost. So how to protect our novelty is first file the patent, then publish. First you have to file the patent, then your priority will be guarded. So you should be first, you rush to the patent office and file, then after that you publish or make that product available to the market. Suppose without applying for the patent, you directly release the product in the market, the technology is known to the public, so it's no longer, it loses its novelty. So it's very important to go to patent office first before it is made to public. There are some exceptions. Like suppose the presentation happened to be a government body, learned people of the government body, or a government sponsored industrial symposium. There if you present, novelty is lost. There such exceptions are there. Or suppose you do it when the prototype is made and you are testing that prototype, somebody accidentally saw that, then there is not a novelty is not lost. As long as you are not offered it for a sale or publicly not displayed. In your lab, you are trusting it, then somebody accidentally sees also, novelty will not be lost. Suppose you wrote these things in a diary and that diary was stolen by somebody, then also novelty will be not lost. Because it is a illegal act of stealing happened, so your novelty will be still protected. You should not publish this work anywhere in the world. Once you publish anywhere, novelty will be lost. And as we explained earlier, invention must be having some application, industrial application. Not industrial application does not necessarily mean industry. It should be useful to the society. Then it is called, it passes the test of industrial application. Non-obvious is very important step. This is most of the inventions get rejected at this step. Non-obvious means, suppose this whatever technical advancement from the prior knowledge which is already existing, that should not be very obvious to a person who is expert in that, who is trained, who is expert in that particular trade. Then it is a novel. And there is an inventive step involved. It should not stuck to that person who is in that trade. This is very obvious. It should not be like that. It should be something novel. It should not be very obvious to the person who is skilled in that art. One of the important aspect is the complexity or the simplicity of invention does not have any bearing on the grant of the patent. It can be very simple, like a paper clip, which it was a recognized invent and patent was given. It can be rocket also. So complexity or simplicity of the idea has no bearing on the grant of patent. Patent is what basically a document issued by government upon application. The one more important step is, if you got a patent granted, suppose somebody infringes, government won't go and take action on their own on that person, You have to find out and complain to government, I have such and such patent. So the patent is violated by this infringer. Like that, you have to give a complaint, then only will act. It is not a cognizable offense. So it is not like you violated traffic, immediately people will take action. Not like that. You have to give a complaint that such and such a patent is with me, so he has violated this patent, then they will take action. So the important question of the today's topic, what inventions are patentable? So this is a question a lot of engineers mind, whether my invention is patentable or not. This one answer to this question can actually clarify whatever in their mind, and it can encourage people coming forward for putting more inventions. So we consulted the controller of patents and copyrights. We asked him, what do you think, what are the inventions patentable? Then he replied, we don't have any list that these are the inventions patentable. Then I asked how you judge. They told there are certain don'ts. I will check don'ts. If all don'ts were fulfilled, then I consider granting a patent if novelty is there. So it is rather answered in a negative sense, but which is useful. What he told, there is no hard fast rules what is patentable with the Patent Office or Patent Act. There are only certain conditions which it shall meet, like novelty, non-obviousness, and extended application, and also certain provisions of law. The certain provisions of law which is against giving a patent are described in the Patent Act under section 3 and 4. We will go to little detail about it, each of the sections. So in general, patent shall be available for any invention, whether it is a product or a process in any field of technology. Here, any field of technology means Patent Office also organized themselves like an engineering college. How we have mechanical engineering, civil engineering, electrical engineering. So there also there is a mechanical inventions, there is a chemical inventions, there is a biochemistry inventions, there is a medical inventions. They are also organized like a departments in a engineering college. So when you apply a patent, it will ask what is the field. Immediately they will refer this patent to that particular field where experts will be there. They will scrutinize the patent whether it is having an inventive step or not. Okay. As explained, since the Act do not list all the inventions patentable, it is imperative to learn what is not patentable. Then also we will be able to understand then what is patentable. So to cover what is not patentable. This what is not patentable was listed in the Act under section 3 and 4. So section 3, exclusions to patentability. So section 3A states frivolous inventions. An invention which claims anything obviously contrary to the established principles of the natural laws. Suppose somebody comes up an invention which violates first law or second law of thermodynamics, no patent will be provided. Because those laws were established, there is somewhere some fault in this invention. So patent is not provided. It should not contradict any existing proven natural laws. So section 3A says, if it is a frivolous invention, no patent will be given. Some examples of it is, suppose somebody comes up with an invention, a turbine which gives more than 100% performance, or somebody claims a machine would continuously run without giving any external power, like perpetual motion machine, which are not possible. So these kind of inventions will be rejected under section 3A. Next, section 3B. Suppose section 3B is somebody comes up with a invention, registration request for invention, whose purpose is against the public order, which is contrary to the public law. Suppose somebody says, I have invented a machine which prints duplicate counterfeit notes. No patent will be given. And suppose he says, I have invented a chemical which can kill thousands of people in 10 seconds. No invention can be given, no patent can be granted. So if it is going against a public order or morality, or it can cause serious prejudice to human, animal or plant life, no patent can be given. These aspects were covered under section 3B. Next. Suppose weapons of mass destruction, biological warfare, so no patents will be given. And suppose somebody invents a device to adulterate the food, so no patent will be given. Then section 3C. This is where a lot of scientists find it difficult to digest why their inventions were not patentable. So if it is a mere discovery of a scientific principles like E is equal to mc square, that will not be given. In abstract theory, patent will not be given. So it should result into some kind of a product or a process, then only patent can be granted. Mere theory, abstract theory, or discovery of a living thing. Somebody suppose going to a forest and find a lion which has 3 legs. It will not be a invention as per the Act definition. So no patent can be given for him that he discovered a 3-legged lion. Right? Any known living things. So even there is a clear distinction between an invention and a discovery. Discovery is finding out what is already existing. Like Columbus discovered India. So he discovered already India is existing. So discovery is not a patentable subject, whereas invention is a patentable subject. Okay. Suppose there is a effort made by a human, a scientist, to develop a new kind of a microorganism. Whether that can be patented? Yes, it can be patented. But suppose you clone humans, you try to clone humans like we do in a film like Rajinikanth has done. Clone a human being, that is not permitted. No patent will be given. Cloning animals or a human is not permitted. Whereas microorganisms, developing a microorganism is allowed and patent can be given. Naturally occur microorganisms, no patent is given, but suppose it is developed in a laboratory, patent can be given. 3D. This is mostly applicable for a chemistry or biological inventions. Suppose there is the crystalline form and amorphous form. Suppose patent is already taken for a crystalline form. Tomorrow you cannot come and say, please give me patent for amorphous form also. So that patent, their patent not given. It is mere for a physical different form of a known substance. So for that, no patent can be. Also, section 3D says, already a chemical already there. Now that chemical earlier known to heal headaches. Now it was found that it also can cure heart ailments. So no patent, a new patent can be given. A mere new use of a existing chemical, patent cannot be issued. Okay. For this purpose, salts, esters, ethers, polymers, metabol, all are considered as a single thing only. Okay. But there is one exception. That is, suppose this crystalline form to amorphous form, crystalline form is there in the market with the efficiency of that product, medical product, is 20%. Suppose it was changed to crystalline form, that efficiency is 30%, higher efficiency. So patent can be considered. Actually, this case was gone to court. The court has interpreted efficacy here means curative efficiency. That is medical and curative efficiency is considered for actually treated as a improvement, and for that form of chemical, patent can be given. Section 3E. Suppose I have a potassium salt, I have a sodium salt. If I both will mix, it will not be any new product. It will be a mixture of physical mixture of things with no improvement in a efficacy or a synergy, then no patent can be given. 3F. Arrangement of data. Let us say some telephone directory. Somebody has arranged in a particular fashion. No patent can be given for that. 3H. Method of agriculture and horticulture. Indian government bans doing patent in a particular method of agriculture and horticulture, because the patent is given for such inventions. Nobody else can do agriculture in this country. So there is no patent given for the method of agriculture or horticulture. But If you invent a mechanical equipment who can give more productivity for a field or something, then that can be patentable. Then section 3I. It's similar to earlier section. Any medical or surgical, curative, diagnostic or therapeutic treatment to humans or animals, no patent can be. Suppose somebody patents how to do operation for a cataract eye, then tomorrow onwards no other doctor can perform this operation. So they are banned. Treating the humans method of treating a human or a treatment to animals are not given patent protection. Section 3J. You cannot patent, as I told, three-legged lion. You cannot patent an existing animal or a plant. Section 3K. It is a mathematical method or a business method or a algorithm or a computer program or some integrated circuit. They are not patented. There is a reason for it. Integrated circuit has a separate IP protection called Integrated Circuits Protection Act. So the circuit can be protected, but no patent can be given on that. But suppose, similarly, computer programs are not patentable. But if the computer program clubs with a hardware, both software and together it will be sold, made for each other, like a Apple iPhone, then patent can be given. Then a literary, a dramatic, a musical artwork, no patent is given because there is already separate IP protection available in the form of copyrights. Normally literary, dramatic, musical works are copyrighted. So since copyright protection is already available, no patents will be given in these fields. 3M. Mere scheme or a method of performing a mental art or method of playing a game or arranging a crossword puzzle, those will not be given as a patent because it's just idea and it is not a product or a process. As I explained earlier, mere presentation of information in some flow charts, telephone directory, diagrams, symbols, or some sketch kind of form, no patent will be given. Topography of integrated circuit, as I already explained, it was protected again with another different kind of IP. That's why the patent will not be given for integrated circuit. With that we completed discussion on various sections of section 3 of Patent Act, where and all patents cannot be given. So whenever some new person coming to do patent, he has to check whether he is violating any of the section A to O, 3A, 3B, 3C, 3D or key 3O. If any of these sections are violating, then no patent is given. So besides novelty, industrial applicability and non-obviousness, these statutory provisions also he has to see that it is meeting. Then comes to section 4. Section 4, the government notified to prevent somebody patenting some inventions in atomic energy like uranium, barium, lithium, such kind of inventions are not allowed in this atomic field. So that since suppose some few people starts patenting this very vast and undeveloped field, then whole India, all the thing will be under their control and real research cannot happen. So it is still under development kind of activity in India, this atomic energy and all. So patents are not ready. Maybe in future, after 25 years, when we are fully into atomic energy, then patent may be given by government at that point of time. Currently, no patent is given in this field. So these are some of the amendments made to Patent Act. Originally, process patents were not there before 95. Then to meet the TRIPS agreement, to align the Indian Act with respect to TRIPS agreement, they started giving process patents from 2000 onwards. So they have started giving patents to mainly biological and pharma patents. These are some of the important features. Like what is the term of patent in India? Earlier it should be some 10 years, 15 years like that. Now it is uniformly any patent, the term is 20 years. And examination of the patent only will be done on request. Automatically patent will not be taken up for examination unless you request it. Suppose you try to do protection patent for any traditional knowledge or something. So there shall be some deposition criteria as per both the PES treaty. So the deposition rules apply. And there is one provision. So this patent, we are all talking about what is to be patented in India. Suppose you want to do in a multiple countries, you need not file many applications. There is an international convention, patent cooperation treaty. Under that, if you file, you can file in India, naming what are all the countries in which you want to do the patenting. So maybe fees and all will be a bit higher, but you can name these 10 countries. I want to do the patenting. You can write here sitting in Chennai, you can apply a patent for 50-60 countries with single application using the patent cooperation treaty. This actually TRIPS and Paris agreement support it. So, well, is there any safeguards to protect common public against somebody patenting and capturing the market but not beneficial to the society? There are few provisions in this act. Compulsory licensing. Suppose somebody invents a COVID drug, but he won't manufacture. He just take a patent and will not allow others to do, but he will also not do. Government can actually force him issue an order saying that you license the technology to somebody else. Since you are not manufactured for last so many months, public needs it. You must license this product. Government can give a direction to the patent owner. Compulsory licensing. Okay. Mainly to deal with the public emergency. And there is, suppose patent were wrongly given based upon a false information, then the government has authority to revoke that patent. And suppose some patent was later found it is violating some security of the nation and such kind of thing, they can revoke. Then what are the stages? Stages of patent is file the application. That is the first important thing. File the application in a prescribed form. There is certain forms in which you have to file and provide the data. Then after that you have to pay the fee, and then after 18 months of the in a normal course of time, your patent will be published in Patent Office Journal. But you need not wait for 18 months. Suppose you are in a hurry, you can apply for a quicker publication of the patent by paying some fee and applying some form 18 or something. So you can hasten the things. Then there is a next step is after publication. From the date of filing within 48 months, you don't ask the patent office to review your patent for consideration. Request for application review. Unless you make it, patent will not be granted. Till 48, so if you keep silent after applying the patent, they assume that you abandoned the patent. So your application will be examined only upon request. What are the important features of a patent application? You should have a title first. Title of the invention, not more than 15 words. Then preamble, then about what is existing, the same field. Name and address and nationality of the applicant. And field of invention. This is important. Field of invention will guide the patent office to send your application to respective branch of engineering in the patent office. Suppose it is biotechnology field patent, it will help that patent office to send to the experts in the biotechnology to verify your patent. Then somewhere you have to mention what problem you solved. That is the objectivity of the invention. So unless this is very clearly brought out, so it can get rejected on the account that it has not met the three principles of patentability. You have to describe the invention thoroughly, complete description along with the drawings and all. Suppose some information you hidden, you have not declared to the patent office, so that can be a ground for not giving the patent, because complete information shall be provided. Otherwise, why in the first place government is giving patent? Because you are disclosing completely all the information, so that at the expiry of patent period, all the data is available to the government. Government can share this to public. Public can actually make use of this your invention. Suppose you made a invention of a drug, chemical or a medicine. Then first 20 years you only can manufacture, you only can import, you only can sell. After 20 years, all the people who are interested can make it. But for them to make, this technology shall be available to them. So you should completely declare the invention, and also you should explain best method of working this invention. Suppose any lacuna is there in this, then application can be rejected. Then the finally most important aspect of the patent application is statement of claims. This is very vital to define the boundaries of your patent. I cannot simply say motorcycle I patented. I say in motorcycle what is the which part of it and which method and what capacity of that item only patent will be given. A very vague and boundaryless patent cannot be given. So stages of grant of patent is, you have many stages. So after publication, once you request for examination, the patent office will examine your patent application and issue a report within normally 6 months, and you have to reply to them. What are the objections were there? You have to reply to the patent office within the prescribed time. Suppose after publication, no opposition, nobody is opposed. People can oppose. After publication, people read and say it is clashing with my existing invention. So then that will be considered. What is the opposition? You will be also called, or sometimes you will be asked, and your reply will be shared to that opponent. So finally, if everything is cleared, only patent will be given. There is a time limit for the opposition. Within publication, the opponent has to respond within 6 months of the publication. Then only the opposition can be considered. Otherwise, the patent office will go ahead with the issuing the patent if all other things are right. But once issued the patent, also there is a remedy. You can go to there is a patent appellate board. There you can say post grant opposition. There is a provision. According to that, you can also challenge. So if that proven right, patent already given can be revoked. And there is a third provision available, which is not in the patent office but in the court. Somebody will infringe this patent, and if you filing that infringement proceeding on that person, he will challenge the very patent concept itself. This patent is violating the concept of section 3D, 3B, 3C, whatever. If he proves that it is correct, then your patent will be revoked. Suppose there are other grounds which patent can be rejected. Suppose somebody has worked it and somebody else stole that work and tried to patent. Then if somebody that complains to patent office, patent will not be given. And these patents, once you file a pay fee and all, you have to periodically pay renewal fee every year. First year, second year, I think they taken for the first application itself. But after third year, second year, and ending third year onwards, you have to pay prescribed fee. Within some, there will be some time permission also within 45 days or something. But if you don't pay renewal fee, your application is treated as a abandoned. And thank you, and hope you understood what is a patentable invention. Thank you.
Like, share and subscribe. Hit the bell icon for more updates.